afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. If you have a question, type it into that comments section below this video, and we will be sure to address it. Episodes are released each week, however, after the live broadcast, so be sure to hit that subscribe icon, hit the subscribe button, and click the alerts icon to make sure you don't miss an episode. I am so sorry that we're getting started a little bit late today. I actually just scooted out of a corporate rep deposition in a case I have against Uber, so I am wearing two hats today, so I apologize. Thank you to those of you who hung in there and are still watching live. Otherwise, those of you who had to head out or really weren't sure if we were going to show up today, I hope that you enjoy the recorded version of this next week. Today, we have Adam Princenthal with us out of Georgia. And as I said last week, I'm really excited about this episode. This is all about having courage. And I got to say, when I got up this morning, about to get into it with Uber Technologies, a multi-gazillion-dollar corporation all over the world, I did not have a lot of courage. I had to muster it up. And so I'm excited to hear what you've got to share with us about this, Adam. Let's get right into it.
All right, thank you, Jenna. If I may here, I'm going to share my screen, okay? And I'll dive into it. Okay, so first of all, good afternoon, everyone. I'm happy to be here, and thank you, Jenna, for having me. When I was first approached and asked to be a speaker on this podcast, first of all, I was honored. And then I was, a little stressed out trying to decide what I would speak about. What they don't tell you what topic, they just say, choose one. And I am on the faculty with the Keenan Trial Institute and teach two different courses. And of course, it occurred to me that I could speak about either of the courses I teach, trial or hit list. And of course, either of those things would have been great topics. But for some reason, there was something that just sort of, pulled me to talk about this topic of courage. It was something I think maybe that was just on my mind at the time and is pertinent to me right now. So I want to talk about courage because it is an essential quality of the trial lawyer. And I believe it is an issue that pertains to all parts of our practice, right? Not just the trial. A lot of the colleges that we attend through the Keenan Trial Institute, or some of us teach, deal with the different parts of the trial or specific parts of our practice, like depositions and mediations. But courage kind of pervades everything, right? So I thought it was an important topic, and it's something that, as Jenna mentioned, she struggled with it this morning. It can be a struggle for me, at different points and different times. I struggle with it to different levels. Now, I have had the good fortune to have had the opportunity to spend a good amount of time with Papa Don, going through training to be on the faculty for the two colleges I teach. I've also been an RA, a referring attorney with Papa Don's firm, and through that experience, I've had the opportunity to attend a lot of workshops at the beach and via Zoom with him, and have had other opportunities to be with him. And I've learned so much from Papa Don, lots of specific lessons on trying cases and litigating and being a trial lawyer. But every time I'm with Don and spend time with him, there's always been sort of two major takeaways that I come away with, in addition to a lot of others. First, as trial lawyers, we need courage. That seems to be a takeaway every time I spend any amount of time with Papa Don, because I see it through him. I see him exhibit it. I see him practice it. And so I realize that, I need to do that. And the second takeaway is that I have too many cases. And that's for me personally. And it's something I've been working on now for a couple of years, and I've been making a good amount of progress in cutting down my caseload. And these two things are related to one another, and I'm going to explain how so a little later in this presentation. All right, so the first takeaway, though, courage. What is it? All right, Merriam-Webster defines courage as mental or moral strength to venture, persevere, and withstand danger, fear, or difficulty, right? Sort of how Jenna was withstanding danger, fear, and difficulty in that deposition earlier today with Uber and their team of lawyers I'm sure they had there. The idea that it takes courage to do what we do as trial lawyers, may seem obvious. We trial lawyers often talk about how we are sort of David fighting Goliath, right? Taking on the big evil insurance companies and corporations, the Taliban, as Don refers to them, right? The black hats that we're fighting. So, I think for a long time I had this belief that simply being a trial lawyer means that I'm courageous, right? That just by doing this job somehow that equals being courageous. And certainly it does take courage to choose this path after we get out of law school or at some point during our career. Papa Don often jokes that, if this scares you or you're not up to it for some reason, you could go do real estate closings. And so there is a certain level of courage just to do this job that is required. But I had sort of an epiphany one day. It was actually during a training when that Jen and I attended together. Papa Don was training a small group of us to teach the new sort of revamped trial college. And we spent a couple of days with him at his office in downtown Atlanta. It's not far from my office. And we worked well into the night. And he was taking us all through sort of the Keenan edge way to conduct a trial. And there were, many lessons in there, obviously. And I highly recommend the college. I'm not going to get into all that right now. But during the course of that training, at one point, I sort of had this sort of moment where the light bulb went off for me on an issue. It was a specific issue. And I had, sort of this little moment of clarity on one level, sort of about a superficial issue. I don't know if I call it superficial, but it was one level. And then that led me to thinking about other things and it got deeper and it got into the issue of courage. So let me talk about that here and tell you what happened. I realized during the training for the trial college that when Papa Don does a trial, throughout the trial, he is having a conversation with the jury. Right? He's not talking at the jury. He's having a dialogue with them. In opening, he says, if you're familiar with the Keenan opening, I'm not going to read these rules to you. You can read them yourself. Just nod to tell me when you're done. Right? He's asking the jury to speak to him through nodding, to tell him when they're done reading the rules that he's put up. He's using demonstratives throughout the trial, and he's putting them up in front of the jury. He's putting up flip charts, and he's asking them, the jury, can you see this? And he's inviting a response. He's having a dialogue with them throughout. In closing, if you're familiar with the Keenan closing, he says something along the lines of, I'm looking at your faces. I see it in your eyes. Your body's shifting. You're talking to me. He's telling them that they're talking to him. And what do you think happens as he's saying those words? They are reacting, more often than not. They're moving. They are speaking to him through their movements and their facial expressions. So he's engaged in this conversation with the jurors. He's not just standing there talking at them. He's inviting them to speak to him, and he's telling them that he's listening to them. So, excuse me, if you know about codes and, the code for lawyers, I'm not going to get into all that, but if you know about that, you know why that might be important. You might also think about, if Pop Don's having a conversation with the jurors, who's not a part of that conversation, right? The black hat. And so, doing this, having this conversation, was very important for a lot of different reasons. And I had this little moment of clarity that Don's doing this. And I said, oh, yeah, there's something going on here that he's not expressly telling us he's doing. And then I realized it. Well, that led me to the next thought. Do I have the courage to have a conversation with my juries? In Georgia, once we pick the jury, from the panel, we get to 12 in the box. The judge has them take their oath, and he gives them their preliminary instruction. And again, it might be different in different states, but here in Georgia, the judges always tell the jurors, during the breaks out in the hallway, if you see the lawyers, they're not going to talk to you and you cannot speak to them. Right? And don't take it personal. The lawyers, they're going to ignore you. They're going to walk the other way. And of course, I'm not going to communicate with jurors outside the courtroom. But is my fear of the judge going to keep me from having a conversation, a dialogue with the jury in the courtroom? Is that fear going to make me stand there and talk at the jurors, to be that lawyer who stands there and talks at them, puts me on code? And I have to ask myself, if I'm honest with myself, is there a fear of the jury itself, of the jurors, right? And does that fear keep me from wanting to listen to them? Am I scared of the feedback I'm going to get if I ask them to read the rules I put up in my opening and give me feedback after they read those rules? Am I fearful of the feedback I'm going to get? And, the question then becomes, well, if so, what do I do so I'm not full of fear, or that I could, at least, whether I have that fear or not, I could act and withstand it, right? Have the courage to act regardless of the fear and move through it. And by the way, I apologize about my voice. I was COVID at the beginning of the year, and I'm still coughing and really don't have my voice back here almost a month later. But anyway, so I feel like I'm losing my voice. But back to the topic. So this little light bulb moment about Don having a conversation with the jury led me to some other thoughts about the Keenan, way of trying cases and things that, we're taught to do. Voir dire, the Keenan pie. It takes courage to do that, as opposed to get up and just do the same old voir dire that every other lawyer who comes before that judge, does. I know the judges might not be familiar with a lawyer standing up and asking jurors about what they're passionate about. And that's going to scare the judge. And that's going to make the judge, react to me. And am I going to, be scared of that reaction from the judge? Or am I going to have the courage, to ask the questions that I need to ask, to get the best jury for my client, for my case? Other examples, of courage. Do I have the courage to do a 15-minute opening and leave out some things that I think are really good facts for my case, and not pack in every single good fact into my opening and turn it into a 45-minute opening? Do I have the courage to do that? I had this little light bulb moment when I realized that Don was, what he does when he talks with the jury. And I had to have a little self-reflection, right? And I had to ask myself, is my perception of myself accurate, right? Am I bad? I don't know what I could say here. Because I left the safety of a big firm, right? I left the safety of a good salary to go out on my own and be a trial lawyer. Am I, some ferocious lion that I want to see myself as? Or am I a little kitten? And if I'm honest with myself, the answer to that question for me has been yes. Yes. At times I'm the ferocious lion, and at times I'm the scared kitten, right? I've been the king of the jungle, and I've been the cowardly lion. If I look back at my career over the past, I've been practicing 25 years, 21 of those, last 21 of those have been out on my own as a personal injury plaintiff's lawyer. So during that time, I've done things that I'm very proud of. Times when I've, acted with courage and fought for my client and for justice and for the community and seeing the results. And then there have been other times when, if I am honest, I folded, due to fear. So Papa Don is big on doing autopsies, right? We do case autopsies, especially when we lose or don't get the result we thought we would get. We look for the root cause, right? We want our defendants, we say they should look for the root cause. Well, we need to do that as well. So what's been the difference between the times when I have, acted with courage and the times I have not? right? Amat Victoria Curum. I don't know how my pronunciation is, right? I went to public school in Queens, New York, from kindergarten through high school, and public college and public law school. So I never took Latin, but I do know that it means victory favors the prepared, or victory loves preparation. And that is the Keenan Trial Institute motto. I think that's, Don believes in that and lives by that. So, fear or courage? How am I going to show up with the black hats and the insurance Taliban, right? Am I going to be a beggar with my cup out, willing to take, some lowball offer? Or am I going to have the courage to walk away, if they don't come with the number that, we know the case is worth at a mediation or during some pre-suit, settlement discussions? Fear or courage? How am I going to show up with the judge, right? When she wants to shut down my voir dire because she's never heard these type of questions before. Am I going to run and hide and say, yes, Your Honor, and fall back into, that old routine of doing those same old tired, voir dire questions that, other lawyers do? Or am I going to be prepared to show the judge with the black letter law why, I have the right to ask these questions? And how am I going to show up with the jury? Fear or courage? If you've attended the deposition college through Keenan Trial Institute, we learn a lot about preparing our clients for depositions. And that spills over into preparing them for trial as well. And, we talk with our clients about how they believe others see them, how they believe their best friends see them, but also how they see themselves, at 3 a.m, right? Their authentic selves. And they have to know what their authentic self is. They have to know about what guilt they may be carrying, so we can address it, right? Because if we don't know that and we don't address it, the black hats are going to pick up on it. They're going to pounce on it. They're going to use it. And the jury's going to pick up on it, right? If the client's not being, her authentic self. Well, the same goes for me. I could come into court with my best suit, acting cocky, trying to play the role of the badass trial lawyer. But if I'm a scared kid, and the jury's going to pick that up, right? I need to convey the fact that I have the courage of my convictions, that I believe in my client, I believe in my case. And that's going to come through. If I don't have the real courage, if I don't really have that, it's going to come through. So in line with the motto, with the Keenan motto, right, I have to be prepared. And there are 3 areas of preparation that I can focus on so that I can walk with courage. I need to prepare my practice. I need to prepare myself, and I need to prepare my case. And I believe that if I prepare all 3 of these areas, I can act with the courage that I need to. I can be prepared for victory. That I'll be victorious with my cases, my practice long-term, and with myself. That I'll be able to look myself in the mirror and know that I acted with courage. Now, that's not to say that I'm going to be perfect 100% of the time, despite preparation. I'm human, we're all human. But in the long term, overall, preparation, will lead to victory. I believe that. So, preparing my practice. Now, let me preface this. I'm going to go through some topics. Let me preface this by saying that, first of all, this is not necessarily an exhaustive list. There's certainly other ways we could work to prepare our practice for success. Secondly, I want to say that, these specific areas of practice that we can prepare, or ways in which we can prepare our practice, this list is not in any particular order. It's not intended to be, the most important first or the most important last. These are just areas that I know that I need to make sure I'm prepared with. So first of all, with my practice, I need to make sure that financially I'm prepared, right? Things like, my firm finances and overhead. I have to think about it. I graduated from high school. From college. I had a short break between college and then law school, I didn't really have a lot of real world experience during that time. Though I was young, I wasn't in business for myself. Went to law school. They taught me all about the law. Didn't really teach me how to try cases, and they certainly didn't teach me how to run a law firm or how to run a business, how to be an employer. And these are things I've learned over the years about budgets, budgets for my firm, personal budgets for my own household, and budgets for the case. It was a long time before I learned about, having a case budget, right? But if I do these things, I'm going to be more prepared for success in my firm long term and to act with courage. Secondly, I need to have a safety net. As personal injury lawyers, as plaintiffs lawyers, I'd say, if not all of us, at least the vast majority of us are working on contingency fees. And, there can be some periods where we're, enjoying a lot of success and resolving cases very favorably and bringing a lot of money. And there could be other periods where it's a little drier, right? And the checks aren't, flowing in. How am I, going to show up during those periods? It's going to depend on how well I'm prepared. So it's good, it's important, I think essential, vital to have a safety net. That means savings, both in terms of my firm having savings and me personally. Also a line of credit. I'm talking for myself. I'm not telling anybody else what they should do. My current firm, my current partnership, we've been together for almost 10 years. We have a line of credit with our bank. I think over the last 10 years, we've only touched it twice. And both times we repaid the money we drew very, very quickly, almost immediately. But it's very important for us to have that line of credit there, because how am I going to react when I'm sitting in a mediation and the best offer from the other side is well below our walkaway number? It's well below a fair number on the case, and I know it's not fair, right? But if I'm fearful about making overhead, about keeping the lights on, about paying my staff, if I'm fearful about my own personal household finances, am I going to have the courage to get up with my client and walk out of there, or am I going to fold and take that low offer? Papa Don spoke about a lot of these types of things during the COVID seminar that he put on at the beginning of the pandemic. It related to COVID in particular, but he talked about how to run your firm during that unusual period of time. A lot of those lessons apply generally. So if you didn't attend that seminar way back, I encourage you to look for it. Second area I need to be prepared, work on preparing for my practice, is the people. Now I know everyone has a different situation with their firms. Some of us have large firms, lots of lawyers, others are just sole practitioners. I'm not saying there's one way that's right or any way that's wrong. But regardless of whether it's your partners, your associates, your staff, mentors, or other people that are part of your community, right? The EDGE community, other professional organizations. The thing is, I need to be supported, right? I need to feel and believe that I'm supported versus being isolated. If I'm out there floating around by myself in the universe, I don't think I'm going to have the courage to take on the Ubers of the world, right? The Walmarts, the Emory Hospital conglomerate here in Atlanta that owns, who knows how many, medical practices and urgent care facilities, not to mention hospitals throughout the state. And I want to fight their lawyers and their insurance companies. I need to have support, and I need to have support from people who have a similar mindset as I do. And that's why it's important for me to have at least, a good part of my support system be part of the EDGE community, right? So not every lawyer at my firm is involved with the EDGE, but many are, and that's something I could lean on. So, for me, preparation in regard to people is making sure I have this support system that I can lean on and not feel like I'm just out there by myself. The next area within my practice that I need to be prepared is case selection. very early on when I hung out my shingle and left the big firm, and I was scared to turn down any case. Whoever called, any lawyer that I knew who referred me in any case, I took it. Any potential client who called, I was scared to turn them down because I didn't know when the next client would call or the next case would come in. And of course, that's a recipe for disaster because I'm going to spend a lot of time working on cases that frankly aren't good cases, right? That are losers. So I have to have a system in place for figuring out which cases I'm going to take, right? A case selection system. Now I'm going to talk about case selection criteria a little later in regard to the next topic, preparing my cases. But in regard to, case selection system for my firm, I need to focus group cases and find out what the focus group is telling me, and specifically about the emotional impact that the focus group tells me they have from the case, right? Brent Crump talked about that when he did this podcast, and he talked about, the reasons we win or lose cases, right? And so if I do a focus group on, initial narrative focus group on a case, and the focus group tells me that it's a 2 on the emotional impact scale, I probably don't need to take that case. Or if I do, I at least need to go into it knowing that I'm probably going to get a 2 when it comes to a verdict, right? On a scale of 1 to 10, if I get any verdict at all. So I need to know that these are cases that resonate with with my jurors, and I do that through focus groups and looking for emotional impact from them, so I can make a decision whether to take the case or not, and just take them out of fear. Finally, my caseload, right? And this, I said, the 2 big takeaways, they relate to one another: courage and the fact that I have too many cases. It takes a lot of time to prepare a case using the EDGE system. Between all the focus groups we do, right? All the memos we prepare, working it up the way, all the versions of an opening statement we go through before we ever get to our final version. Writing the opening, video recording it, playing it for a focus group, taking their feedback, revising it over and over till it's perfect, working on my rules. Doing all this takes a lot of time. If I have too many cases, I cannot prepare the case correctly under the EDGE system. If the case is not prepared correctly, how am I going to show up at a mediation, right? If I'm sitting in the mediation, I know this case is not really prepared, and we're on the next trial calendar, and if it doesn't settle here, I'm going to trial in a case that's not really prepared. Am I going to show up there in fear, or am I going to show up there with courage? So to have courage, I have to, have the right caseload for me. Now, none of these things, the financial aspect, the people, case selection, caseload, there's no one size fits all. I'm not telling anyone that you need to, have a certain number of partners or associates or staff members. You don't have to do it the same way we do at my firm. I'm not telling anyone you have to have the same number of cases that I have. Everyone has a different practice, but it has to be the right one for you, right? It has to be, the caseload has to be a caseload which allows you to prepare your cases correctly. For me, that's a certain number. For Jenna, it might be a different number. Some of us have firms with, a lot of cases and a lot more staff and a lot more lawyers, and you can work them all up correctly. Some of us are true sole practitioners with maybe one paralegal, and to work up the cases correctly, it's going to be different. The practice is going to look differently. But the point is, I need to, be prepared in these areas. Otherwise, I'm going to feel out of control. My practice is going to be out of control, and that's going to show up in the way I handle each of my cases. All right, next, preparing myself. And this is, maybe probably the most difficult area to prepare, right? And again, like I mentioned with preparing my practice, this list is not exhaustive, and it's not presented in any particular order of importance here. Just ways I can prepare myself. So number one, as far as just being a trial lawyer and the actual trial skills, the skills that we actually bring into a courtroom, I have to practice. Papa Don preaches that. And as great of a lawyer as he is, as much success that he has had, as long as he has been doing it, he's always practicing. He is in a perpetual focus group. Wherever he is, whoever he's talking to, he's focus grouping, right? And he talks about this, in different presentations, right? If he's in an Uber or a cab, he's doing a focus group with the driver. If he's standing outside a hotel smoking a cigar, he's doing a focus group with the doorman, whoever else is standing out there. He's doing these focus groups. That's practice. It's practice speaking to the jury, right? It's practice listening, maybe more importantly, to the jury. So he's always practicing. And if he's practicing, then I certainly need to practice. I need to practice all of these skills. All right. Secondly, another way to prepare myself, self-awareness. Again, I touched on this earlier. The deposition college, we talk about, client preparation. And we spend time preparing our client, and the client has to get to know, their authentic self so they can be authentic. Well, I have to be, honest with myself and try to get to know my authentic self. And part of that's knowing my strengths and my weaknesses. Papa Don talks about the fact that, he took voice lessons in the past. So if that's something that can make me better, or I believe could make me better, then that's something that I might want to do. All right. I need to know what my, when I talk about weaknesses, what my fears are. All right. Am I controlled by what others think of me? So I will tell you that personally for me, I've worked on myself to know enough about myself to know that that's been a fear for me throughout my life that I've struggled with at different times to different extents. Wanting other people to think well of me, wanting the accolades, wanting the people to think I'm, whatever, doing a great job, a great lawyer, a great guy, whatever I want them to think. Well, what does that, how does that manifest when I'm, in a hearing with a judge, arguing about whether some, evidence that should come in or not? Do I want the judge to like me? Am I so fearful about what the judge is going to think of me that it's going to affect how I, fight for my client and for my case? Same thing with the black hat throughout the litigation and mediators. And that's a big one for me. And here in Atlanta, there's a lot of mediators, but there are sort of a certain select few that are known to be, the best mediators and get used a lot in a lot of good cases. And I tend to work with them a lot. And I've known a lot of them for a while, and I get to know them, and I like them, and I believe, we're friendly. Do I want the mediator to like me? Is that going to affect how I show up at the mediation and what I do with the mediation? If you take the mediation college to learn about the mediation, the Keenan mediation letter. And, to be transparent, that is one of the things that to this day still causes me a lot of fear. Sending that mediation letter. And why? Well, if I'm honest with myself, part of it is, I know if the mediator finds out that, I'm saying that, if they don't come back with an offer within 30 minutes, we're getting up and leaving, the mediator is going to be upset, right? And they're not going to like that. And they're going to be angry with me or upset with me, and I think about, this little game that, a song and dance the mediators play at the beginning of mediations. And I'm sure we've all experienced it, where they sit there and tell our clients, how great we are and how lucky the client is to have Adam as a lawyer, or Jenna as a lawyer. And, well, I'm not saying they're lying. I think the mediators probably, think well of us and but why are they saying that? It's, they're doing that, at least to a certain extent, to manipulate the client and to manipulate us. And I know it intellectually. Right. Even though I know it on an intellectual level, at this emotional level, I feed into that. And, he's talking about, he's saying how great I am, and I don't want to now upset him. Right. I think about some businessman sitting in a strip club, and the stripper is flirting with him, and he's like, he knows it's BS, but he's just, feeding into it. Well, I want the mediator to like me. Right. So is that going to, knowing that about myself, though, I can address it, right? And I could say, okay, I'm not going to fall prey to that. I'm not going to fall victim into that trap. And I'm going to be prepared with that. Another area under this topic of self-awareness is, what is my relationship with suffering? It takes courage to be with the suffering of others, right? And do I have the courage to be with the suffering of my clients? And if I can't be with the suffering of my clients, can I present their suffering to a jury? I think about Papa Don's story that he talks about, spending the night at the home of his client, who was a young boy who was blinded. And he's sharing the bedroom with the boy, and the boy says, hey, can you get the lights? And, the kid's joking because, of course, he's blind. He doesn't know if the lights are on or off, right? And, Don tells that joke or that story, and it's kind of a humorous little story. The boy's joking, and he kind of gets Don for a minute with that. But, if you think about it, the boy's sharing his suffering with Don, right? He lives in a permanent state of darkness. And when you realize that and you really sit with that, it's not comfortable, right? And can I be with my client and really spend time with them and get to know their suffering? And I would suggest that I can't do that really with my clients if I don't have the courage to be with my own suffering. And everybody has suffering. Of course, I haven't experienced being blinded or any other, catastrophic injury. But every human, experiences some suffering. We've all experienced betrayal, right? So can I sit with my client's betrayal and really get to know how they've been betrayed by the doctor who, malpracticed on them and left them paralyzed, or my client whose son, they failed to diagnose a stroke and he's now permanently brain damaged and will never be the same. Can I be with her, suffering? Well, I don't think I can if I can't be with my own. And so I need to know that about myself, right? So I could deal with it one way or the other, so I could be prepared. Otherwise, I'm never going to do justice to my own clients, to presenting my clients' damages to the jury, right? Next, in regard to preparing myself, for me, I need to have a purpose. And we all, I think, are familiar, Don has the Keenan Kids Foundation, which is, a great purpose, he's had for years and years now, and has done a lot of great, work and, donated lots of money to this, cause. So that's a purpose. Of course, serving my clients, individual clients, is a, primary purpose in all my cases. But, for me, I need more than that too. I need a broader purpose. And that we get into the case selection criteria there, right? So if I'm looking at a case and I'm doing that case selection criteria that, if you haven't read, the blog, it's in the first reptile book, talk about, what random victims could have been injured, why should the community care, what happened that can happen again. If I'm in touch with that throughout the case, that's going to give me a greater purpose too for each of the cases I'm working on. A purpose of trying to serve the community, not just my client, right? Not just an individual, but the community as a whole. Don talks about the fact that he reads that case selection criteria memo before he does closing. So, that's not something we just do at the start and forget. It goes throughout the case, but, it really, helps give us a purpose, or broader purpose, for our practice. And that kind of goes hand in hand with this question. These two things are related. Why did I take the case? I was in a workshop with Don, and my partner was there, and we were there together working on one of our cases with him. And he asked my partner about our case. And he said, why did you take the case? What were give me the 5 top reasons why you took the case. And, this is a case that had been going on for quite some time, and you have to think back to that first meeting with the client, and he asked my partner because he did the initial meeting with the client. He had that first meeting. So the first time you sit down with the client tells you a story. Why did I take that case? Hopefully it's not just about money. right? I mean, financial aspect is going to be there, but hopefully there's more to it why I took the case, because, doctors should care about their patients, and then, corporations shouldn't, put products that are going to, injure or kill us out into the community, right? Premises owners should make their, apartment complexes safe for the tenants who pay rent to live there. So if I keep in touch with, why I took the case, that also gives me a purpose, and as I'm feeling a purpose to my practice, to my life, to my, for myself, that gives me courage to take on, the Ubers and the Walmarts. And finally, having mentees helps give me purpose. Don has mentored, I don't know, countless and countless attorneys. I see that as an example, and I, personally can attest to the fact that, I've done it to a much more limited scale, but when I share whatever knowledge I may have or experience I may have with a younger lawyer or a less experienced lawyer, that gives me purpose. And when I feel like, hey, I'm doing that and I'm showing someone else, boy, it's hard for me then, it makes it a lot harder for me to fold, right, in the face of a little bit of difficulty or danger in my own cases when I'm trying to be an example to somebody else. The last topic I'll touch on in regard to preparing myself is mindfulness, which has been something that I've been, practicing for a while, and I find it to be immensely helpful in my life in general, and my practice as well, and practicing being a lawyer. Jenna had Joe Tunstall on a while back, and he did an episode on this podcast regarding stress relief, and as part of that, he talked about mindful meditation. So I, recommend that episode in general. But for me, mindfulness and mindful meditation is a daily part of my daily routine. If you're not familiar with it, I encourage you to check it out. There are all sorts of books out there, apps you can download on your phone, things you can look at online to get introduced to it. It could take as little as 5 minutes in the morning or much longer if you choose to. But basically, if you're not familiar with what it is, it's a practice to help us become aware of what our thoughts are and being aware of our thoughts. Because I think like most of us, I have a tendency, a thought pops into my head. I'm not aware that I'm even having that thought. Next thing I know, I'm on this, train of thought, this train of association, and I'm down the line. And, the thought will pop into my head, and I'll keep it directed at my law practice, but it comes into other parts of my life. But in regard to my law practice, the thought will come, I'm going to lose this case. And that thought will come, despite how much preparation I put in. And then it's, how much money I have invested, how much time I have invested, and I'm going to let this client down. What am I, my partner's going to think? What are my colleagues going to think? And, I'm off and running on this train of association. I don't even realize it. I'm being taken down the line by these thoughts that are controlling me, right? A meditation teacher who I like, he calls thoughts little dictators. Thought pops up, tells me to do something, I'm doing it. If I'm not aware that I'm having the thought. But as soon as I become aware that I'm having this thought, that I'm mindful of it, then I realize what it is. The thought, there's nothing to it, right? There's no substance to it. It's like a cloud floating through the sky and it's just gone. As soon as I'm aware of it, it dissipates. It doesn't have any control over me whatsoever. Whereas if I'm not mindful of it, boy, then I'm starting to act out of fear. I'm going to lose, I got all this money in the case, I got all this time, the client, she's going to get nothing. I better take that settlement offer, but when I see that thought, for just, nothing, which is what it is, I don't have to act out of that fear. I could act out of the courage, right? Because I know, my case is prepared, right? Which leads to the last area of preparation, preparing my case. I'm going to talk about this, but what I'll first start off by saying is, if you haven't done so already, just go through the colleges, start off with, introduction to the revolution and then go through them from, rules and case selection all the way through the graduate level courses, and you'll know exactly how to prepare your case, right? Much more so than I can, start to touch on here. But I will attempt to do so briefly here. So case selection criteria, I already mentioned this, right? Random victims, why the community should care, how can this happen again? I need to do that for all my cases and keep that in mind as I work up my cases all the way through the trial. I need to know the codes in my case. And I need to know the POV, a point of view, a point of vision of everybody involved, right? From my client to the defendant, to the black hats, to the judge, to the jurors. I'll talk about, since the courthouses have reopened here in Georgia, basically in 2022, they opened back up, at least in the metro Atlanta area. We had 3 trials in 22, one of which ended in a mistrial. We're waiting to retrial the case, so I won't say much about that here. But the other 2, I call it the Bates trial. My client's name is Mr. Bates. He was on a motorcycle when he got hit by a distracted teenage driver. The Hamilton trial is a premises case against Walmart. There's lots of codes involved in those cases, right? With motorcyclists, distracted drivers, teenagers, Walmart. The Hamilton case, my client was a grandmother. There's codes for grandmother. I had to know all those codes. And the thing is, I did know all those codes. I was familiar with them, and we worked those throughout the trials, both of them. And because I knew the codes and I knew what the point of view was of the jury about these different players in these trials, I was, it gave me a level of courage I wouldn't have had otherwise. I also think it led to, good successful results in both cases. But going into the trial, I had levels of courage because I knew how the jury would react to certain types of people and situations. Obviously, we need to have our safety rules. We need to work those up, and we need to focus group them. Motive, not an element of proof in a civil case, but we need to know what it is, and I need to get that from the focus group. I might think I know what it is. I could fall back on the tried and true, profits before people, but maybe that's it. Maybe it's not. I need to find out. I need to find out from the focus group. The emotional buttons. I need to know, where they are in my case. Again, I might think I know where they are. There's some lie, and I think it's a big deal, and then the focus group tells me it's not. So I need to know what is the emotional button that is a big deal. Is it the betrayal, the hypocrisy? Is it a lie? I have to find them, and I have to focus group those. All right. If I know I have the rules, the motives, the buttons, then I have my case winning hits that I could weave throughout the case, in every deposition, right? Throughout the voir dire, throughout opening, all the way to closing. And if I know these things and I focus group them and tested it and I weave it throughout, I know, I'm confident it's going to work, right? I'm confident that I'm going to be successful, right? That preparation is going to lead to success or victory. And so that's going to give me courage. Client preparation. I've talked about the deposition college. I can't recommend that highly enough. For me, probably for a long time before I got involved in the Edge and before I took the deposition college and started preparing clients the way we do it, for me, defending my client's deposition was always the scariest thing I did, but short of a trial, let's say. I was always so scared of what my client was going to say during the deposition or not say. Since I started preparing them the way we do, I don't have that fear anymore when I've done it properly. But then again, that goes back to if I have too many cases, I don't prepare them correctly. I'm sitting down in a deposition, and boy, do I feel the fear in the pit of my stomach. My openings, I talked about, working them, reworking them, videoing them, playing for focus groups till we have it down. My demonstratives, I got to work on those early. I can't wait till, a week before trial, start figuring out, what demonstratives I'm going to have and use because I need to test them. I need to focus group them. Focus group, focus group, focus group, from the beginning all the way up till before trial. And then, of course, pervading all this is I need to be prepared with the black letter law, at hearings, but especially when I walk into trial, right? I need to be prepared with the law to respond to the objections I'm going to get in voir dire and the judge's reaction to some of my voir dire questions or the statistic or my use of certain demonstratives, right? I have to be prepared with that law. And if I'm going in there and I've got my trial notebook and I've got the trial briefs, I've already sent the judge, and I know the law and I know I'm right, I'm going to act out of courage, right? I'm not going to shut down and fold. All right, I see it's 4 o'clock. I'm at the end of my presentation, which is perfect because my voice is about to give out completely. Stop sharing my screen.
That was awesome. Thank you so much, Adam.
Thank
It's
you.
interesting as you were talking, we'll go a few minutes over just so that the audience gets the full bang for their buck since we started a little bit late. But, I as you were talking, I kept thinking about different experiences I have had with courage. And one thing that I was thinking about is the things we have to do to gain courage are not comfortable, but we feel more comfortable when we're courageous. So, doing things like getting onto a Zoom call with your client or going to their house or whatever you do to spend all of that time we do preparing our client, it's not comfortable for everybody. Sometimes I have to gear up to get on there and spend a full day with my client going through their fears and their concerns and learning about their childhood. It's not supernatural, but you will feel courage and you'll feel comfort in that courage if you do it. So I hope that resonates with people out there. I don't know if that's what you're going for, Adam, but I wanted to share that because it isn't always comfortable getting to that place, but the courage will give you comfort.
Definitely. There's a phrase or quote, or, if it doesn't challenge us, it doesn't change us, right? So I have to go through that discomfort. I have to do things that are uncomfortable, but I'm going to be better for it.
Exactly. And one time we were talking about, this was at Dawn's, I think it might have been in Georgia, and he was talking about engaging with the jury during voir dire and focus groups. So both times you have a little bit more flexibility in how you engage with the jury. And he was talking about calling people out for just different things like, your hair is a certain color, or you have, you're in crutches or whatever. And I used to remember telling him, I was like, I don't feel comfortable doing that. And he straight up asked me, do you think you're in the right profession? Do you think this is right for you? If you can't step outside that comfort zone a little bit and, do things that are a little bit uncomfortable and give yourself that kind of empowered courage. And it was a really interesting question, honestly. And some days I wake up and I think, nope, I am not in the right profession. This is not for me. I don't know what the hell I'm doing here. Other days I wake up and I'm like, yeah, I think I am going to be okay today. And so, it's okay for those of folks who are listening to this, that there are some days that are filled with courage and there are some days that are filled with absolute terror, because we're, like you said, Adam, we're all human.
Right. 100%.
Let's see, what other things did I want to highlight from your, one thing that was interesting too is courage comes in all elements of what we do, not just in trial, not just when we step into that courtroom, but in mediation. You have to have the courage to maybe upset the mediator and make that person, frustrated with you because you want to do something a certain way that isn't what they want. And that can be very scary because it's outside what we've been taught. It's outside maybe some unwritten social rules of mediation. But if you do it and you're doing it respectfully and with good reason, you'll find that in the end, the mediator may respect you a lot more and you'll have a better relationship with them. So, throughout, whether it be with court reporters, with opposing counsel, with all these things that make us uncomfortable, if we do it with conviction and respect, and even though it's scary, it will give us courage.
Definitely, my fears and things I'm fearful about 99% of the time are unfounded, right? So my fear that someone's not going to like me if I do this, it's not necessarily true, right? And most of the time it's not. But that's just that thought, right? That I could believe in or say no thank you to, right? It could pop around and say no thank you. I don't care.
Absolutely. All right. Well, I think we have come to about the hour point. So thank you so much for that presentation, Adam. A lot of really wonderful things to consider when we are giving ourselves courage, because guess what? At the end of the day, that is where courage comes from. It comes from ourselves. And, we might get accolades or compliments from other people, but if we're not feeling that deep down inside, it's going to be a barrier for you to be the best advocate you can be for your client. And hey, that's why we're here, right? The client and the safety of the community. So thank you to all of you who joined us this afternoon for this week's episode of Fridays with Keenan's Cutting Edge. Again, I'm sorry it was a little bit delayed today, but I'm so glad that we could make it work out. If you like today's episode, please click the thumbs up button to feed the YouTube algorithm. Let them know that you find the content interesting. Sign up for alerts so you don't miss an episode, and share with your friends. Next week, we have Doug Dykes back with us to talk about 7 major takeaways from the Keenan Law Firm Fellowship Program. This is an awesome program that Don does by granting one lucky person every year the opportunity to go down to the beach, live basically the Keenan Law Firm, live and breathe everything they do. So really neat opportunity. I'm excited to hear from Doug because I believe he was one of them, and that's why he's coming to speak on this. So I'm excited to hear about his experience and what others can expect if they choose to take that opportunity. Have a wonderful weekend, everyone, and I will see you next time.